Betsy, you've done a tremendous amount of work in criminal appeals. What do you think a person that's just been convicted at trial looking for an appellate lawyer, what would you want them to know about embarking on that process?
I think the first thing that you need to understand about the appellate process is that it's much, much different than a trial. First of all, people think about trials and they think of Perry Mason. Well, that's not even accurate at all, but when you talk about appeals, it is completely inaccurate. When you have a trial, you select a jury, you present evidence, you may object to that evidence, there will be closing arguments, and then there'll be a sentence. When you undertake an appeal, there is no additional evidence that the court can consider. You have what is called a record on appeal, and sometimes we call it a cold record. And by that we mean that any evidence that you did not present at trial, in most cases you are not going to be able to present to the appellate court. So in many ways we think of an appeal as a pure legal process. The personalities fall away, the emotions fall away, and we are looking at what legal and constitutional issues can we raise to either get the conviction vacated or to get the sentence vacated. So when we are looking at appeals, we are looking at a much different process than we are trials. The other thing that I think appellate courts do that trial courts don't do, and in many, many high-profile cases is very, very important, is to take the public sentiment out of the negotiation and out of the process. For instance, when you see what we call the kiddie porn cases or child sexual battery cases or even animal cruelty cases, you can see a great deal of emotion and public sentiment that can, in some situations, influence the outcome. When you are handling an appeal, you are looking at the pure legal issues. And so what is very, very important to have is someone that can sift through the record, can glean the facts from that record that are going to put you in the best position for the Court of Appeals, and then has the research and writing skills, A, to locate the cases that would be to your benefit, and B, to present them in such a fashion that you're going to convince the court that the trial court committed what we call reversible error. Many people think that if something happened wrong at trial, that may automatically mean their conviction can be reversed, and that is not true. You must show the court why this particular error is of such magnitude that the conviction and our sentence should be reversed or vacated. The other thing that is different in the appellate process is you do not have one judge. You have a panel of 3 judges. In Jacksonville, our Court of Appeals is the First District Court of Appeals, and that is located in Tallahassee. After you receive the record on appeal and you review it, the lawyer is then going to file what we call a brief. And in that brief, the lawyer is going to present all of the facts that the court is going to need to look at the conviction, and additionally is going to present all of the relevant case law to the court in an effort to convince the court that the conviction should be reversed. The initial brief is filed by the person that is claiming that the conviction should be reversed. After that, the state then has the opportunity to file what we call an answer brief. And of course, the state's going to be arguing there was no error, and even if there was error, it was not of sufficient magnitude that the conviction should be reversed. After that, the appellant, which is usually the defendant who has been convicted, will file what we call a reply brief. And that is a very short brief that is in response to what the state has argued. We always request oral argument from the Court of Appeals. It is not always given. Because of the volume of appeals, particularly in our First District Court of Appeals, there are many, many cases that are resolved without the opportunity for oral argument. Again, oral argument is not like a trial. You don't go and get to present additional evidence or argument that was not raised at the trial level, and your time frame for arguing is much less. It is literally minutes rather than days. So when you present oral argument, you must have the ability to focus on the important issue, to the court so that the court can look at what I call these core issues and determine whether or not you have sufficiently presented both case law and facts that the court will feel comfortable in reversing your conviction. After you've argued your case, you don't always get an opinion out of the Court of Appeals. In Florida, there is a procedure called per curiam affirmed, and that means the court does not render an opinion. The reason per curiam affirmed is kind of a thorn in the side of all criminal appellate lawyers is if you receive what we call a PCA, you do not have the ability to further appeal your case to the Florida Supreme Court. So when we are handling appeal, we are attempting to really laser focus what the issue is to the court, presented it to the court in such a fashion that they want to hear oral argument, and then present it in such a fashion that they want to render an opinion, and more importantly, render an opinion in your favor. The other thing that one of the reasons that I have a passion for appellate law is you see these cases time and time again, and the most recent case that I read was an elderly man who was 72 years old walking his pit bull. He very foolishly let the dog run after a cat. The dog killed the cat, and lo and behold, this 72-year-old man not only was tried and convicted for animal cruelty, he was sentenced to 3 years in prison. At his sentencing, the prosecutor brought in literally thousands of letters. There were people in the courtroom. It was an emotional circus. There was no way that the 72-year-old man was going to get a fair sentence. What was his remedy? There was no other remedy than the Court of Appeals. And fortunately for him, the Court of Appeals ruled that while he may have been very foolish to let the dog chase after the cat, it was not a crime. Additionally, the Court of Appeals admonished both the prosecutor and the trial court for their brazen attempt to influence the sentence by what they called mob mentality. So the hope is that if you have these high-profile cases, and there has been a mob mentality, cooler heads will prevail in the Court of Appeals, and you will be looking at the legal and constitutional issues, and all of the emotions of a criminal trial will be set aside, and the court will do the right thing based upon the case law. It has been my experience that appellate practice is not something that you pick up. It is not a hobby. If you are going to be an appellate practitioner, it is very important that you constantly read. The cases come out on a daily basis, almost on an hourly basis. So what could have been the law even a year ago could not be the law today. So it's very, very important that your attorney have the resources to do up-to-date research and the ability to do that so that when that lawyer is arguing in front of the Court of Appeals, they have the best possible scenario, the best possible argument to present to the Court of Appeals. I personally am passionate about it. I love it. I love the give and take, the intellectual give and take. But it's also important as an appellate attorney to never forget that you're representing actual people with actual problems. And while there is somewhat of an intellectual pursuit, there's also a person at the end of that appeal process, and it's just really important when you are making your argument to the court that the court knows that there's a real live person that's going to be impacted by what the Court of Appeals decides.